Here at Gas Digital, we want to help you be better in bed, which is why I want to tell you about our partnership with Promescent, the premier sexual wellness company, which is fancy talk for here's how you can be a better lay. So how is Promescent going to make you a better lover? The greatest thing that ever happened to whoever you happen to be sleeping with? Promescent has a patented delay spray that's going to help you last longer in bed. With Promescent, you can last longer, have more fun, and show your partner a really good time. So if you go to promescent.com, promescent.com, they've got an assortment of products to enhance your sex life. If you use promo code WELCOME15, you get 15% off. Once more, that's promo code WELCOME15, and you get 15% off. Let's start the show.
Fill her up.
You're listening to the Gas Digital Network.
Good afternoon, Michael Malice here. Let that be your welcome for the next hour. We have with us my friend and First Amendment attorney and just general badass attorney, Ron Coleman. If you don't follow him on Twitter, you absolutely should, because he's one of the few people who knows how to make his own reaction GIFs, and they are often hilarious. Ron, you have been front and center with regard to First Amendment litigation involving several major cases. And I think what's interesting, as I'm sure you've seen, as soon as, let's suppose, Merrick Garland isn't seated for the Supreme Court, everyone on Twitter and Facebook instantly becomes constitutional attorneys and will start telling everyone whether this is correct or incorrect. So people actually have, it's very much like Plato's Cave, how the legal system works. So you've been involved in several cases with friends of mine. The big one that you have been involved with recently was the Dc Drano case. Can you tell people, and this I think was kind of setting some semblance of precedence, can you break down what that case was and why it matters?
Well, it's actually very fresh, so we don't want to use the past tense. It was only filed a few weeks ago.
Oh, okay, I misunderstood. Okay, I got
in the Central District of California. There has been talk in the last year or so, and particularly in the last 7 or 8 months, about this idea that moving away from the rather wishful concept that courts would treat social media like the public square, which I've done the research, I've read the cases. The Supreme Court's not going to go there. It probably could, but it's not going to. So the question was...
Can I interrupt you? Because there's a lot of legal issues here, and I really want to get the technicalities for the audience. Is the idea that the court is, that the social media is a public square, is this something that would tend to be more of a progressive view of the law, a conservative view of the law, or does it cross both ideologies?
Well, it's a great question, because the reason it's not going to happen is precisely because of the conservative justices.
Yes, I knew it.
If you knew it. Now, which I think I would only say if you were able to rewind the clock, because now outcome-oriented justices, particularly
Amy Coney Barrett?
No. I mean on the left.
Ruth Bader Ginsburg? Sonia Sotomayor?
Ginsburg's outcomes are completely determined at this point. Yes, Sotomayor. So Justice Sotomayor, who sometimes comes through brilliantly, but sometimes seems to merely just be doing something else, it would seem to me, be very unlikely to consider that a progressive goal now because of the way things align. But historically, it would have been a progressive goal to say that any place that is, as a practical matter, a public square, and that I don't think anyone suggests that the fact that an environment is online rather than being a physical space should be the determining factor there, should be treated as a public square for purposes of the First Amendment, whether or not speech can be restricted there by those who have authority over the public square.
Right. Can I ask one more thing? Is public square an actual legal concept that's been codified?
No, not codified. It is, however, a public forum is actually really the term, and this would be a matter of judge-made law.
Okay, that's what I'm asking. Okay.
Right, judge-made constitutional interpretation. The question is, even if who has the authority to regulate what happens in the common, in the public forum? Well, not a private actor,
right?
Because that person, unless they use improper force, can't stop you from getting on your soapbox and declaiming. Only the government. So if it's something is a public forum, then the only restrictions the government can impose are reasonable time, place, and manner restrictions. The question then becomes,
let's break that down. So that means because this is technical stuff that I think people need to be informed about. That means, yes, you can have a speech in this gazebo, but you can't be blasting your music there at 12 at night with 1,000 people, even though it's a public square. There are limits where it becomes, okay, come on, guys, this is not free speech anymore.
Safety considerations are relevant, and timing considerations are relevant, and manner, as you said, the difference between playing music. And these tend to be very vague, but there are lines of cases with respect to all the different criteria. And judges mostly get it. They know what they're talking about here. So the question then becomes, how about private spaces that operate more or less the same way? We have seen that shopping malls, as a general rule, although there was initially in the 1950s a glint of suggestion that perhaps shopping malls or company towns would be treated like the public square, it comes out that the only time that's relevant for a company town is if there's a law. You see, a lot of people are confused about the fact that the most well-known case involving this issue involved the application of a California state law that said if you own a shopping mall, thou shalt treat it like a public square. In other words, you can't restrict speech. Very progressive. Property owners brought a Fifth Amendment takings challenge and said, you're taking our private property from us. Supreme Court said, no, this is within the realm of what a state can do. That's very progressive. In other words, it's not a conservative value. The Supreme Court, when it looked over the succeeding years of the 50s and early 60s, that people or judges might take that too far and really undermine property rights more than the court was prepared to do in those days, unless those properties belong to, say, landlords of New York apartments or something like that. Right. That's an outlier. It's an outlier, and it's inapplicable to the situation that we're in now. So now that I've told you what this is not about, the question still becomes, what if the government itself is actually behind, either implicitly by virtue of threatening regulation unless X, or explicitly, as we have now seen is going to be the case, telling social media platforms, here is misinformation as we define it, and here are the people who are broadcasting it, publishing it, and you need to help us clean up Dodge in terms of information and messaging. There's a very well-established legal principle that the government cannot outsource to private actors that which it is prohibited from doing itself. Otherwise, all the constitutional rights become meaningless.
Yeah. Right, you can't have Dog the Bounty Hunter arrest you and not read your Miranda rights and to go to, take him to court. Right. Right.
So a couple months ago, well, there was a Wall Street Journal editorial at the beginning of the year. It was in January, actually, that said, look, it's becoming more and more clear that there is a quid pro quo between government, largely Congress, and the social media platforms, which is if you don't start doing things the way we like to see them in terms of the message, basically in terms of censorship, we're going to start regulating you. And perhaps that's enough. There is a line of cases that says under certain circumstances that would be enough. What we have now is that Judicial Watch in the spring got from through a FOIA, or it might have been state FOIA request in California, a trove of documents.
Right. So explain to people, FOIA is a Freedom of Information Act. That means if the government has certain files on you, ask to have that data, and they're obligated to give it to you, and often it's redacted.
It doesn't always have to be about you. It can be about any matter of public interest that is within. If the government does it, they don't have a presumptive power to keep information and documents confidential from the public. They have to justify why they don't share it with the public.
Yeah, they have to err on the side of transparency is the legal principle.
That is the legal principle that is disregarded on a consistent basis, especially by the FBI and the Justice Department and the State Department. They do so because judges let them.
Yeah,
and there's just an understanding there that judges are going to let the federal government, in particular, do what it wants. But in this case, the state government of California was diligent and compliant and produced tons of emails demonstrating that this bureau that they had set up to address issues of election security, play FBI music in the background, okay? Election security was coordinating, first of all, with 22 other attorneys. This was an office in the Attorney General of California's office. They were coordinating with 22 other attorneys general, all Democrats, through the auspices of the National Association of Attorneys General. And by the way, remember, this is where Soros has spent all his money in the last, not all of his money, but a major, major emphasis in the last 5 years. And
well, now you're just an anti-Semite.
The best. The best. So,
wait, I got to ask you, as both tribesmen, how does it make you feel when you have people running interference for Soros and saying criticism of him is anti-Semitic?
As someone who has personally been called a Nazi and a capo more times than I can count, nothing surprises me. These people are just, that's their religion.
Historically, leftism would say, correctly, if there's anyone who should be under public scrutiny, it's an international billionaire who's using his money to affect political change. That's the boogeyman for the left, and they're not wrong. For all of us, it's like this guy's the whole. But then when it's Soros, it's like, whoa, whoa, whoa! What are you, a Holocaust denier? I got called a Holocaust denier because I said to call George Soros a Holocaust survivor in the same terms as Anne Frank is really, and as a means of deflecting criticism of him, is really pushing it. And the guy from The Atlantic is like, that's softcore Holocaust denial. It's like,
I was expecting one of those great Michael Malice analogies here, and all you said was really pushing it. I thought you were going to give me something. It was like calling Pepe the Frog, the Disney of the 21st century or something like that.
Yeah. So it was just shocking to see that this is who the one person you can't criticize. But anyway, I'm sorry. It's a side.
Yeah, no, that's fine. So all these guys were so there are emails going through social media posts and telling Twitter who's got to be taken down.
Wow.
And they banned Rogan O'Handley, who's DC Drano, who has well over 2 million. I think you might have heard him say 3 million followers on Instagram. He wasn't as big on Twitter, but he only had hundreds of thousands of followers on Twitter.
Yeah.
On the grounds of being a threat to election security. Why? Because he wrote this is a pretext, in other words.
Sure, of course.
He wrote a post questioning the way California maintained its ballot integrity and chain of custody. And they said, well, that's really inaccurate. He's giving people the wrong impression about how we do things in California. Okay. So he's wrong.
Yeah.
Or he's right.
Yeah.
And that's a ballot security issue. Oh, footnote. His post was made, his tweet was made after the election.
Wow.
Was that of course, remember now, now the election in the United States in blue states went on as long as necessary.
Right.
To get to the right outcome. So that might not be a fair complaint, but it certainly was after Election Day. So he's got these smoking guns. He and I have had.
And let me say one more thing. Is it legally material that, and I know the answer, but I still want to hear the attorney's perspective, that these were places for him to increase his brand and revenue. So therefore he has material damages as well. It's not just hurting his feelings.
Oh, well, actually, it's material, but it's less material than it normally would be because here he has been deprived of constitutional rights.
Yeah, right. Okay.
So unlike the case where I tried desperately to enunciate a cause of action on behalf of Laura Loomer, which still causes Popat's friends, like any chance they get to pull something up, Pacer, to try to induce Ken White to mock me, which I think he's really past, to tell you the truth. But I mean, these people are so pathetic. The court didn't want to hear it. They didn't want to say they didn't consider it to be cognizable damages. That CARE had conspired with Twitter, told Twitter. Here was a private company, right?
Yeah.
Oh, it's a private. So two private companies. Anyway, that's a case I'd rather talk about as little as possible, but because I got killed. But in this case, we sued. We did sue Twitter, but Twitter is the last defendant. The Attorney General of California, whose name is Padilla, is the lead defendant. The other attorneys general of the other states that were involved are defendants, as is the National Association of Attorneys General. And the reason you're hearing about it from me, and I'm explaining it to you in such detail, is because there's been practically a complete blackout on the case. So firefighters have found other smoldering wrecks to run in. You got it.
Is it the case that if you are suing attorneys general and the Attorneys General Association, there is, generally speaking, practical purposes, a prejudice in their favor since they're members of the bar and members of the same kind of system? Hey, auto mechanics and super cool do-it-yourself guys who work on their own cars. I want to tell you about rockauto.com. It's the online store with every auto part at the best prices. This is your one-stop shop for everything auto parts. rockauto.com has been in business for 20 years. They make it easy to find the parts you need at the best possible prices. No more talking to counter guys who need to order your parts, which sounds like hell on earth, aren't really sure what you're looking for. They never have quite what you need, and then after the hassle, they're still charging you storefront markups. At rockauto.com, you can easily find everything you need, whether you're a mechanic, an auto shop, working on your own car, or just a car enthusiast like myself. Everyone has access to the same incredible pricing at rockauto.com. So if you're a car guy, and who isn't, right now go to rockauto.com, check out all the parts available for your car. You're going to have so much fun looking at car parts. Once more, go to rockauto.com. No promo code needed. The pricing's already that good. And when you order, make sure to tell rockauto.com that you heard about them on your welcome. rockauto.com. Let's get back to the show.
Well, there are a couple of things. One is that as a legal matter, the actions of any state, of any government unit, you'll find this as a libertarian or anarchist particularly amusing. You know this already. As a legal matter, any government action is vested with a presumption of regularity.
Yeah, right.
Meaning the cops, all things being equal, prima facie, the cops know what they're doing.
Yeah.
The government's here to help you. So that's number one. That's always going to be the starting point. The interesting thing, though, is that the Association of Attorneys General is not in and of itself a government agency. So it won't have that benefit. But culturally speaking, okay, I want to make a point. A lot of people on Twitter, when they see crazy outcomes or they see politicians doing things that strike them as a dereliction of duty, they say this crazy thing where they say, what do they have on him? he's corrupt. And what they don't understand is that no one has to have anyone, like John Roberts, first, besides the fact that he absolutely did not go to Alita Island, there's no proof of it whatsoever. He doesn't have to be the subject of blackmail.
Do you mean Epstein Island?
Yeah, well, Epstein,
I thought you said Alito Island.
No,
I misunderstood you. Lolita. Okay, I thought you said Alito Island. Like this. He's got one too?
Alito hasn't been there either.
Yeah, okay.
People don't have compromising stuff on these guys. These are the squarest people in the world, especially Roberts. Alito, too. These guys are utter stiffs.
Yeah.
They're doing what they do because that's exactly who they are.
Yeah, yeah.
That's how they succeeded. That's how they maintain their success and their self-image. You don't need to have anything on them. It's not about that at all. So there's this gigantic, so that's in terms of their own space. But yes, there is this discretion and this benefit of the doubt that government units get. But on the other hand, there is such a long history. Well, think of it this way. Trump was not, even though the law required that, Trump essentially was never given that. If Trump did so, I mean, we reached a point where members of one of the circuit courts were asking whether what Trump meant during, and the Supreme Court overturned this, what Trump meant during his campaign when he said certain things, in order to figure out what his motivation was for issuing an order. That's ridiculous. All right. We're getting off course. So yes, your question is a good one. Do you have an up? But what I am saying is that judges aren't all that shy about overturning what governments do, or looking at what governments do. Governments are sued all the time.
Sure.
And that's always a problem. Suing the main problem with suing a government unit or a government agency is that they have limitless resources.
Right.
They do not answer in any meaningful democratic way to whether it is cost effective to deploy money or personnel to defend a lawsuit. And yes, there are relationships. See, I will tell you what's more of a problem, what you're talking about, is where the people you're suing are closely involved with the judges themselves. In other words, they're the kind of people that they're likely to rub shoulders with. In this case, California is a gigantic state. The political people in the different parties certainly know each other well, but it's not going to do an attorney general from Massachusetts a lot of good in California.
Okay. Gotcha. So go ahead. You're talking about the Soros.
I was talking about Soros? Oh, so the point. So we brought this claim under Section 1983, which is the statute under which you proceed when someone has been deprived of their constitutional rights. So that's why it's not this typical commercial litigation having to do with deplatforming. Rather, it has to do with the argument is that the Twitter acted as an arm of the state. And once it does that, then you're entitled to assert your First Amendment rights against the state. The state had no right to put Twitter in that position, but Twitter also should have resisted.
Yeah.
And they can't merely say, we were forced. They'd have a very hard time showing they were forced because in reality, all they were really, at best, it's, I would say that they're going to be in a position of saying, we thought it was okay because the government told us to do that. But on the other hand, there is testimony regarding Facebook from Mark Zuckerberg, where he actually apparently brought this point out when he was before Congress and said, if you're asking us to do a lot, I think he was responding to a question from AOC, which, as you can imagine, was brilliant and pointed. And she said, well, can't you do more to stop hate? Or can't you do more to improve the smell of unicorn flatulence, whatever it was. And
you can't improve that smell. That's the best smell. No one can. See, she is dumb.
All right, so here we are.
So I'm not surprised that this case has not gotten coverage, because this seems to be, first of all, it's going to be very hard to make him out to be some kind of Nazi or some kind of, crypto terrorist, right? And it does not pass the sniff test, especially among people who have their roots in the 60s, lefties in the 60s, where you have this collusion between big corporations and the state behind closed doors. Ayn Rand, the vampire novelist, had an essay in her old newspaper where she was talking about the FCC. And the article was called "Have Gun Will Nudge." And she was talking about how censorship isn't done by, I'm going to ban this person. It's the head of the FCC calls up the radio station and it's basically like, look, is this really the kind of person you want on your radio station? Don't you want to be a good corporate citizen? It's like, oh, right away, Mr. Minow, I think was his name, Newton Minow. So that sort of thing where there's not even really a threat of coercion, but it's like, I wash my hand, you wash your, we wash each other's thing. It's like, it really is, even if they legally have a right to do so, which I'm not in a position to say this, among the population, this is something that a lot of people will be like, wait a minute, I really don't like where this is going.
Well, it's gonna, let's put it this way. It is gonna test the increasingly, stunningly disappointing capacity of people who call themselves children of the 60s.
Yeah.
To ignore the fact that they've become absolute tools of elite institutions and from business to government. I mean, everything they claimed that they stood for turned out to be. The only question is in that favorite cross-examination question: were you lying? Are you lying now, or were you lying then?
One of the ways that will get people to realize just how deranged Washington is, and I never thought I'd see the day, but watching Bernie Sanders, that moth-ridden old hippie, talking about how we have to trust this, I think it was either CIA or FBI. I was like looking, I'm like, who are you? Yeah. Like, if that's the one thing I would expect you to be good on, you're not even a Democrat, you're independent all your life, you're from Vermont. The CIA, this is your bête noire.
And this is our so-called communist.
Yeah.
Get us some real communists.
The communists like the secret police. Good Lord. So let's talk about this sort of thing. And I don't want to talk too much strategy because I know you don't want to show your hand publicly. But broadly speaking, is this the sort of thing where you were talking about how governments have resources? Do they tend to have as a strategy in cases like this, let's draw it out and just drain the guy of his legal fees and hope it collapses? Or is it, this is ugly, we have an incentive to settle and just sweep it under the rug? I would think that since they have unlimited resources, it's just going to be all upside for them to just drag it out.
Actually, no, I would say not, because as a general rule, the one thing they don't want, especially that Twitter doesn't want more than is the discovery. And the longer we have, so all the energy in the world gets put into the motion to dismiss.
Yes. Okay.
And the beauty part here is that it is in the federal system, so there are no interlocutory appeals from a motion to dismiss. So they have to, even if we get an opinion that goes our way, and I say even because you still have to make it happen. This has never happened before. It's a case of first impression, and judges are funny things. But if for some reason things don't go go our way, and for some reason being that we're very good at what we do, my partner is Harmeet Dillon. She knows the California scene intimately. The Section 1983 is her mother's milk. It's a perfect storm, a perfect case for us. Rogan and I are friendly. We're all working on it together. We've got the Center for American Liberties raising funds for us. Money's probably not going to be a problem, even though, yes, it's less of a problem for the bad guys. They are going to put all their energy into that initial motion to dismiss, and they're inevitably going to ask us, probably on the eve of the due date, for an immense amount of additional time to prepare the motion to dismiss. And we might have some back and forth on that because every day that our guy is not on Twitter, he's being damaged. So, there's an argument here. But if we get past it and we get discovery, they're going to want to settle very fast. They're not going to want, and Twitter in particular, which I would think has a motivation. They do have that sort of leverage, leverage in terms of their position, their optics, to say, look, we really just we had to pay the bribe or we can't do business. That
just
kind of
following
thing.
orders. Yeah.
It's still a disaster for them.
Okay.
And I will tell you that last, we were on Dave Rubin last week, and Rogan, DC Drano, couldn't have been more clear that he is not interested in a settlement.
Yeah.
He wants to open it up here. He wants to break this open. And there really is an interesting question. How long has this been going on?
Yeah.
How long ago was it planned? I mean, this is a gigantic potential case. Gigantic.
Yeah, because if you're fighting for free speech in a broad sense, right, and the choices to you are, okay, either you're going to really draw a line in the sand that's going to help a lot of people and further the values that you believe in and think are good for the country, or I'll give you back your Twitter account and some cash. To me, this seems like a no-brainer.
But people like you and Rogan and me are really outliers.
Okay, yeah, sure. But I mean, for this case specifically,
but that's why we're in this position.
Yeah.
That's why we're having this discussion and why people are probably even going to listen.
Guys, I got to tell you about sheath underwear. I love sheath underwear. They're the only thing I wear as underwear, and the only thing I'm wearing right now, other than a pair of paisley socks. I'm not joking. Here's why I love sheath underwear, the official underwear of hunks and studs everywhere. It's made of a stretchy fabric, which wicks moisture away, super soft, that's great. What makes them special is their dual pouch technology that keeps your man parts separated, prevents them from sticking together. Support the underwear that supports you. If you go to sheathunderwear.com and use promo code Malice20, you get 20% off your order. They've got new materials I've tried out, bamboo and mesh. I like them both. I really like the mesh because they really keep you nice and cool, especially in these hot summer months. With sheaths, there's no more chafing, no more sweat, just comfort and support, and you'll be one step closer to being a hunk. Who doesn't want to be a hunk? Well, apparently everyone else at gasdigitalnetwork.com, so I'm picking up the slack. Sheathunderwear.com, Malice20 gets you 20% off your order, and now we get back to my favorite stud, Ron Coleman.
So let me ask you about, you also covered, you were the attorney for Carpe Donktum, my buddy, Logan and Rogan. And he was, for those who don't know, he was President Trump's meme maker. He made some videos that went very viral. They were absolutely hilarious. One of them I particularly remember was there was a Trump State of the Union or address to Congress. I'm 90% sure State of the Union. And he took the REM song, Everybody Hurts. And as Trump is, being triumphant, he had shots of all the Democrats in the audience looking like sourpusses and just being absolutely miserable. And it was just hilarious just because they're like just the way he cut it together. This was a copyright strike because I think REM or the music company got ass mad. Fine, they pulled it. He returned it with different music. And he was very effective. And President Trump retweeted his stuff all the time. He did my full disclosure. He did my little video for my book release, The New Right, which came out a couple of years ago. And he got kicked off Twitter for having like copyright infringements or whatever it was. It was very clearly fair use is a thing. It's very known in the internet. It was clearly being targeted because he was being effective, in my opinion. I don't think there's much dispute about that. But he was recently sued. If you follow him on Instagram, Carpe Donktum, you can see him there. And that case got thrown out. Correct?
Yes, he was sued along with a couple of other defendants. Trump something. He and the president at the time, Donald Trump, was one of the defendants, and the Trump Organization was one of the other defendants. We only, although we represent the Trump Organization in other cases, we did not in this one. So we both we and they made motions to dismiss, and it's kind of funny because it's like they filed a gazillion pages worth of motion to dismiss, and Ron Coleman doesn't do million-page motions to dismiss. I do lean, mean motions to dismiss for tactical reasons having to do with how motions to dismiss are supposed to work. Anyway, both of us got our dismissal. But
wait, can
what
you
was the
explain
case?
that?
Yeah.
Because that's abuse. Like, why is it advantageous to have a shorter, more succinct motion dismissed than a longer one?
Okay, so let's first unwind. What was the lawsuit? Although Logan was banned because of a supposed copyright strike, the obvious lawsuit for them to bring would have been a copyright infringement claim in federal court. There was, however, no copyright infringement because of fair use, and also because they probably didn't have such great copyright. In fact, I don't know if they ever even registered the copyright. If they whatever the reason was, it would have been a very quick death in federal court. So eventually, and they really schlepped this out, but eventually they sued in state court under these Byzantine theories. Now, you said something that if the case was still underway, I would have to have stopped recording and said, you can't say that because you said that Carpi was President Trump's meme maker. In fact, although he eventually got to visit the White House, he was completely independent. And when
That's
the president
correct, yeah.
liked his memes, he would retweet
Yeah.
them.
Yeah,
Just like
there was-
the
right.
President Trump used to retweet me all the time. Never. He never retweeted me. But they said it was obvious that Carpi was really working for the Trump campaign.
Okay.
And how do we know that? Because he visited the White House later, and that form made him more prominent.
Yeah.
Some kind of, and this was an unauthorized use of the personal image of these two little toddlers who you can barely see in this fuzzy video. And that Trump had a financial stake in doing this because everyone knows that the only reason he became president was to make money.
Okay.
That's right, to make money. Which actually would make sense if you look at like Barack Obama. He's a very wealthy man.
Yeah.
He wasn't that well off when he started. So, but I don't think there's a very good case for that in Trump's case. And that this was going to somehow, that if he would be reelected, that would enhance his financial opportunities.
Okay.
And there were like 5 or 6 different versions of the same claim, which was this sort of misappropriation of a likelihood.
When you're as an
of likeliness, I'm sorry.
As an attorney, when you see that argument, is there a part of you that just sits there shaking your head being like, who comes up with this shit?
No, there's a part of me that gets extremely excited.
Oh, because, this is going to be fun to eviscerate.
Right.
Yeah. Okay.
Yes, because it's like shooting fish in a barrel, which exactly is what it was. Because I know who comes up with stuff like this, people who are not very good at what they do.
And you also know the judge, who are, I think, to some extent fair, is going to have to, ask this person questions, the other attorney, and you're going to have to watch them tap dance, and it's going to be like, come on, guys.
Oh, I'm going to tell you a little bit about that in a second.
Okay.
But now we filed our motions to dismiss. And yes, so a motion to dismiss on the pleadings, in both, whether it's in federal court or state court, is premised on the idea that, Judge, even if every single word they say is true, we're not admitting it's true, but let's just say it were true. It still wouldn't be a lawsuit. They would still not have a legal right here. That's called a motion to dismiss on the pleadings or a failure to state a claim for which relief can be granted. When you make a motion to dismiss for failure to state a claim for which relief can be granted, you are required to stick to the 4 corners of the complaint. In other words, Judge, if you just look at what's been filed, it doesn't stand up. Now, there's a great temptation among many lawyers to file a bunch of affidavits saying what they say is not true. Here's why it's wrong. Here's why it can't be. You're now adding evidence that is not within the 4 corners of the complaint, to which the judge might say, that's interesting. Sounds like there's a lot to talk about here.
Yeah.
There are really facts that I think maybe require investigation.
Oh.
Or he'll say, or she'll say, I want to, this is really looks more like a summary judgment than a motion to dismiss on the pleadings. Let's have both sides make their submissions.
Okay.
I've just lost the opportunity to say my original argument, which is that this doesn't add up to anything. So
don't go past the sale is kind of the equivalent.
Right. Exactly. So I'm a purist, and luckily this was one that, I got to handle my way entirely. But the fact is we both won our motions. During oral argument, the judge was very good. Look, this is a New York State Supreme Court judge. So two things. One is that in New York State, first of all, Supreme Court does not mean the highest court. It means court that is not small claims court, traffic court, municipal court,
right.
Family court. The Supreme Court justices, as they're called, in New York County, which is Manhattan, that's a really prestigious gig. Those are good judges. Our judge was obviously unprejudiced, but our judge was quite good. And he wanted to know, he was asking exactly the kind of questions I would want him to ask. Like,
okay,
what, Mr. Coleman, why do you say this? Why, giving me the opportunity to flesh out stuff that had already been submitted. And when he went to the other side, he said, he's asking them, well, what are the requirements under this New York law for unlawful appropriation of someone's likeness? Is that it has to be for a commercial use, not for some kind of commentary.
Right. I'd make a Ron Coleman action figure and sell it.
Right. Which would be, which would hurt the sales of the real Ron Coleman action figures available at roncoleman.com.
If you pull the string, it chases an ambulance.
If I were fast enough to chase ambulances, I wouldn't have to do this crap to make a living. So he says, well, Judge, the President Trump the only reason he wanted to get into office was to make money. And the judge, he said, guy's a Democrat, okay?
Right.
The reason the president wanted to become president was to make money? And he says, yeah, but it's well established, Judge. And the judge says, are you saying that every politician now is to be deemed acting as a commercial in commerce because they have the opportunity to maybe make money later after they leave office? He just couldn't believe, his eyes were bulging out of his head, could not believe what he was hearing. And ultimately the guy is arguing that the reason they should be allowed to proceed with this case was because was that Carpy's meme, remember now, we made a mistake. We didn't show we didn't explain to people who are listening and watching what the meme was. The meme was, of course, a parody on the toddlers running toward each other. And it was a little bit of a heavy-handed meme. And it was heavy-handed because at this point, Carpy was looking over his shoulder and disclaiming his tuchus every opportunity he has. This is really not, but the joke was, if CNN had put together this video, what they would have said was, look, a black toddler is running away from a white toddler. America's burning, race relations. And what the guy was saying to the judge was, they're promulgating a lie about race relations in this country. How can we possibly permit that? And we're just all sitting there with our mouths open. You want the court to accept as a premise that race relations are a disaster and that lying about them is against the law?
Yeah, right.
It didn't go well. So we won that. Yeah, we did get a very good decision on that, although the court did not award us sanctions.
Okay.
Which it seems, according to the statute, he probably should have, but that far I can't go.
But doesn't that almost never happen?
Well, but New York passed an anti-SLAPP lawsuit statute with real teeth in November, and this was an anti-SLAPP lawsuit if ever there was one. So that is a chapter that has not yet been written in this case.
So here's a case that the last time you were on my show, I haven't heard much about it since. What? Why'd you make that face?
No, yeah, it's just it's painful. I'm
You got all blurry.
Yeah.
Yes. Okay. The Southern Poverty Law Center doesn't want to talk about this. So you were representing Gavin McInnes, and he was suing the SPLC. I haven't heard anything about this in a very long time. I know last I'd heard Gavin was insisting that he wants to take it to discovery. Can you update us on the situation with that case? Because they've been very effective at banishing him from the internet.
They killed him. It's really very problematic what happened with that case. The case is exactly where we left it.
Oh.
We filed our complaint, was it at the very end of 2019? Or was it 2018? Losing track. They made it was 2 years ago, 2019. No, it was the end of 2018. The Southern Poverty Law Center, this was a defamation claim against the Southern Poverty Law Center based on the stuff that they put on put on their website about him. He filed it right. He filed the lawsuit at the end of the year. They made a motion to dismiss. Again, an encyclopedia full of stuff that they filed. We filed our opposition to the motion to dismiss. By April of 2019, the judge had all the papers from both sides. The ACLU made a motion to come in on the side of the SPLC.
Oh, wow. Okay. Really?
Yes.
Why would they stick their neck? Oh, wow. Historically, we think ACLU is defending Nazis in Skokie, right? So why would... Go ahead.
Oh, because here it was defamation is an un-American cause of action.
Okay.
And SPLC should be allowed to,
say what they want.
Say what they want. And we actually... This is usually when the ACLU asks permission to get involved in the case, they are allowed. Although getting involved at the trial level and at the motion to dismiss level is unusual.
Okay.
We opposed their request to participate as amicus curiae, and we won that motion. The judge said, no, it looks like both sides here are adequately lawyered up. We don't need that. So that was a little chip shot. 2 years later, we have no ruling. No ruling.
Is that uncommon?
Yes, it's uncommon, especially in a relatively sleepy district court like the Middle District of Alabama. It is very interesting to note that the case was assigned to a judge who has senior status and who seems for some reason to completely randomly always get assigned cases involving the Southern District, the Southern Poverty Law Center.
Oh, wow. Okay.
And who is the only liberal judge in that court. And that's the Honorable Myron Thompson. I'm not saying anything untoward has happened. I'm sure he's a very busy man. But there's not much you can do as a litigant if a judge refuses to rule on your case. 2 years is not considered to be enough to complain to the court above him. And it's really a shame because the damage is really done. I mean, It's true if we overcome the motion or we win on an appeal if the motion is granted, that it'll be stunning news and it'll be great for Gavin. But meanwhile, 2 years have gone by where he has been defamed and continues to be defamed. And, they say that justice delayed is justice denied. It's certainly been delayed and denied here. It's really it's a tragedy. And people who donated to this case have rightfully asked me from time to time, Ron, what'd you do? You take all the money and first of all, the money's not all gone. But second of all, who on earth dreamed that this would ever happen? There are real problems with our judicial system. This is an example of one of them that can happen.
Hey guys, I want to talk to you about Blue Block's blue light glasses, BLUBLOX. So if you're staring at computer screens all day, feel overworked, you feel tired, trouble sleeping, this could be blue light damage, and BlueBlocks.com is here to help. They created these incredible blue light glasses that block the blue light coming off your screens that causes your eye strain. And they did this because the founders weren't happy with the quality and lack of science behind the leading blue light blocking glasses, so they decided to make your own. Here's what you can do. If you go to blueblocks.com/you're-welcome or enter code WELCOME at checkout, you get 15% off your order. They have over 40 frames to choose from. They've got them in prescription, non-prescription, and readers, frames for every need. And speaking of need, for every pair you buy, Blue Blocks will donate a pair of reading glasses to someone in need. I think that's pretty cool. If you go to blueblocks.com/you're-welcome or enter code WELCOME at checkout, you get 15% off your order, and it'll help you be a little more relaxed. Let's get back to the show.
So let's talk about that. So I was very privileged to have you read the John Hassness essay for the Anarchist audiobook. And that essay is titled The Myth of Objective Law. And he basically makes the point that the concept of objective law is a fallacy, that we all interpret things with our own ideology or worldview, and that to expect what is the right answer and things that are, and he breaks out several cases where you can very easily see both points of view. And so his conclusion is that it'd be preferable to have a market-based polycentric legal system where people can basically court shop depending on picking what rules. And one example of this, we have this right now, is if you are Muslim, you could go to your private Sharia court, you could have private arbitration, and the private arbitration could have it, well, you can't come into this court if you're wearing a dress, and them's the rules. So I would love to know what you thought of the essay and what you thought what he got right and what he got wrong.
Well, I've actually been involved in quite a few Jewish-based
that's another one. Yeah,
cases, and in fact, I was recently involved in one where the arbitrators were so incompetent and so and I'm not saying they're any more incompetent than any given group of judges who could have, I'm not saying that at all, but their decision was actually overturned by a court because.
Well, I'm sorry to interrupt you. Let me give people an example of something that he uses in the essay, which I remembered, which is this. There's a contract with an old lady, and she got basically screwed because she signed a contract to pay 10 grand for tango lessons or something like that.
Right.
And the lawsuit is, okay, we have to break this contract. This is ridiculous. She's an old lady who got exploited. And the point he makes is there's two ideologies that both make perfect sense. One is it's not the court's job to break contracts because when you're picking and choosing which contracts, you basically violate the whole concept of contract. And the other one is, all right, when something is so obscene that it defies justice, it is the responsibility of the government to come in and defend people who are either ignorant or just, weak or whatever it is, to make sure we don't have an outcome that is so perverse in the face. And when you put in those terms, he's and he goes, and this was actually a legitimate case. He wasn't just using it as an example. So I'm sorry, go ahead.
All the examples he gave actually are based on first year law school classic cases that are chosen by the people who write case books.
Okay.
And the professors who teach out of those case books to illustrate these points, to get young prospective future lawyers to think about these issues. He was drawing largely on the literature, and I think he acknowledges this, of legal realism.
Yeah.
Which I was first exposed to in law school, and which I have seen. When you're a young lawyer, you're rather idealistic.
Sure.
And you really think if you make your best argument, and then as things go on and as your experience accumulates, you begin to see what's really going on. And so many judges, I'm not saying this to carry favor with anyone, so many judges really are trying to do the very best job they can. And the examples he gives of the male and female judge who have these parallel careers, and where they're both really preposterously rationalizing to reach their desired point of view. It's an exaggeration. There are very few judges who are so obviously outcome, oriented, although there are some that are frightening. Having said that, so he's right that there's a problem. And that the idea that there's an absolute truth in the law is probably incorrect. But he doesn't make a very strong argument for private law.
Okay.
For a couple of reasons. And one of them is, I was teasing you a little bit about this in a DM, where he talks about, look how great collective bargaining agreements work. Collective bargaining agreements are just a great example of where people choose, a specific pre-decided, arbitration provisions to deal with labor management conflicts. Dude, the only reason there's such a thing as a collective bargaining agreement is because the state coerces the recognition of labor unions, which could not be recognized in the absence of actual or threatened violence, because they are a cartel of labor focused on a particular industry or company or location that says, we're going to strike, and if you go in to take the job that we have not taken at a lower price, we'll break your legs.
Yeah.
So that to me makes the entire enterprise of the collective bargaining agreement just completely inapt as an example. So let's go to private law, though, to arbitration. I think I can. The best example, I think, to prove my point is that one of the most common forms of arbitration that consumers get involved in is securities arbitration. Someone says, my broker did a terrible job. I told them to sell, they didn't sell, or they were churning my account. And the securities industry got Congress to pass quite reasonably a law that says, these kind of disputes are going to be arbitrated because we're going to clog up the courts with it, and it's going to cost people too much, blah, blah, blah. And what everybody knows is that there's an entire industry of securities arbitration that is specialized. And the arbitrators and the arbitrated are, in many cases, people who were one or the other just a few weeks ago. And although there are many people who do very well as plaintiffs, as consumers in securities arbitration, most consumers would rather have the option of working outside of that system because there are a lot of limitations that are placed on them. And again, the decision is made by the state that thou shalt arbitrate. One of the problems with arbitration is, in fact, that it's very expensive to do right. The idea of arbitration once was that it would be less expensive than litigation because there would be there'd be a lot less discovery, a lot less, you're not going to have a jury. At the same time, professional fees were much lower when the American Arbitration Act, or when it was the Federal Arbitration Act, was passed. And one of the ideas of arbitration was that a typical arbitration would involve 3 arbitrators. Each side would choose one, and then they would agree on a third. Nobody can afford 3 arbitrators today, except in the biggest commercial matters. Okay. Arbitrators who are any good charge, in the major cities, 5, 6, 7, 8, or 4 figures an hour. Judges don't charge anything.
Yeah.
You can't afford, so you end up choosing one arbitrator. There is, for all practical purposes, notwithstanding the example that I gave before, no appeal from an arbitration. It has to be something really smelly, really bad. The idea of arbitration with 3 arbitrators was that if you have 3 arbitrators, you don't have as much of a need to appeal because at least one guy in there is going to be making the case for, not because he's biased, but he has the perspective of the people who brought him into the case. With one arbitrator, you either win him or lose him. Just like, we say, trial lawyers frequently say, and I think it's true, that juries decide cases on the first day, maybe even well before lunch. Are arbitrators so different? I don't think so. So with one arbitrator, you have both lost the ability to appeal, and that's one of the other aspects of private law. Now, you might say, why not set up your private law paradigm that in a way that permits appeals? You could. You definitely could. But I think at the end of the day, he identified a real problem, but didn't really grapple with, rather, the problem of unequal bargaining positions. Now, in the case of the old lady who bought the dancing lessons for 100 years, that was a novel case because she did negotiate the contract at an arm's length. Nobody pressured her. She just wasn't really with it. She didn't really think through. She didn't really think someone was going to take advantage of her that way. And that's part of the reason that case is taught in law schools is because it's it brings these issues out to light. But as a general rule, the party with more money or the party with more power in any given transaction has more ability to decide what the terms are going to be. And if you tell me that we're going to agree to arbitration, by the way, I can afford attorney's fees, you can't, and that the arbitration will not include punitive damages because I'm going to be paying them, you won't. And whoever loses the arbitration has to pay the attorney's fees to the other side, which I don't care either way. I'm a multi-billion-dollar corporation, but it'll ruin you, et cetera, et cetera. It's those kinds of inequities that are what lead people to form systems of law that are, presumptively, although not necessarily actually, available and open to everyone. And also you have this idea that there are open proceedings, and that's controversial. Should they necessarily be? I'd like to ask him, maybe he's written about this elsewhere, is his argument for, I think it would, his argument for civil, against the law monopoly apply to criminal law also? I think he did. I think he actually does say that it would.
Yeah.
I think most people have a natural discomfort with that. We need to move toward a place where they have at least as much discomfort towards the criminal law system that is in place now, which is a shanda, which is an absolute disaster, especially at the federal level. That's gotten worse. It used to be better. Now it's worse. A lot of moving parts here.
Ron, we're running out of time.
That's why I put in the ellipse.
What has been your favorite part of this interview?
Looking repeatedly at what seemed to be flying hot dogs behind your head in that poster. I'm wondering if, no, they're pills. Are they capsules?
They're red pills.
They're red pills. That's been, no, you know what? In reality, it's always, anytime you and I hang out, we have fun, Michael, and this has been no exception.
Case dismissed.
Hey everyone, before we go, if you enjoy this podcast, you might enjoy some of the other podcasts available at gasdigitalnetwork.com. This week, we're highlighting Zach Amico's Midnight Spook Show with host Zach Amico, who is low-key, easily one of the funniest people on this network, and a great dude. You can find the full catalog of episodes on demand at gasdigitalnetwork.com or catch the latest 15 episodes anywhere you find podcasts. Here's a clip.
Zach Amico's Midnight Spook.
Yeah, so they've established somebody knows how to get out. Oh, fuck. He doesn't beat the fucking shit out of him.
God!
Get the hell out of here.
He's a trap!
No!
Go right
Oh my God!
He's endangering the planet.
Let
him go, you Nazi!
What the fuck? Yo, shut the fuck up, Karen. He just almost killed me. Oh! That's what we doing now? Damn, you know that's Chris Brown's dad. Oh! Snap! Oh!
Like father, like son.
Damn! Oh, man. He's doing...
God help you, Quentin.
Yo!
Did you smack your kids around too?
Oh, my
Son, she with the shit.